Well, good morning, everyone. It's morning my time here during the pandemic, and I'm excited to bring to you the presentation with regard to concurrent planning. My name is Buffy Okuma. I'm currently the Chief Deputy District Attorney for the Child Welfare Unit in Washoe County with the Washoe County District Attorney's Office. I do want to let you know I have some other experience as well, though. Not just from the agency attorney side. I also was a juvenile master in the 2nd Judicial District Court, handling child welfare cases primarily. I also was a child's attorney for a time period. I think I'm going on 20 years in child welfare, extremely rewarding, which is why I've been doing it for so long. Concurrent planning is something that was introduced early in my career, basically with ASFA, the Adoptions and Safe Families Act. And so it's been something that we've been trying to work with, but haven't been doing quite as well as we should. So that's why we're doing these practice guides and this training today. So I'm going to go ahead and go through each of the slides and give some practical tips as well as the areas where the law does describe what concurrent planning is. So looking at our agenda, we're going to talk about why we're doing these practice guides and these trainings. Then I'm going to talk about what concurrent planning is and the role of stakeholders. So as you probably know, the federal government reviews each of the states with regard to their compliance with their state plans through the CFSRs. And as a result of that review, the federal government determines whether or not we have met all of the requirements that they have set forth or whether we have not. As you probably know, we did not meet the requirements. And as a result of that, the state is required to enter into a program improvement plan, oftentimes referred to as the PIP. The PIP had a number of different components of the various areas that our state did not comply with the federal requirements. And one of those areas was with regard to permanency. And one of the areas that they identified as something that we could improve with regard to permanency was the use of concurrent planning. So throughout the PIP, the various areas are identified, and then the plan is set as to how we're going to improve that. And in this particular case, it was identified that we would have updated policies with regard to concurrent planning, the concurrent planning practice guide that is going along with this training, and then this training that would be presented to various groups in various settings, but also would be available for people to review on demand. So with the program improvement plan as it related to concurrent planning, and what's not reflected in this slide is the findings that the federal government along with the stakeholders made. And key to those findings with regard to concurrent planning were that we had an inconsistent use of concurrent planning across the state. And they identified one of the reasons for that inconsistent use was that there was no agreed upon understanding about what it is and how it works. We're going to talk about what it is and how it works, and that we're going to attempt to have more consistent practice across the state and have more consistent use of concurrent planning. And one of the key issues that I want to drive home, and you'll probably hear me say it a few times, is that there's a difference between concurrent planning and a concurrent permanency plan. Concurrent planning is steps that are taken throughout the case. It doesn't require a permanency hearing, it doesn't require a court order, and it's best practice. And so when we think about concurrent planning versus a concurrent permanency plan, I think that this will get us to where we can have best practices. Some of the things that we saw across the state as demonstrated by the inconsistent use is in some jurisdictions, The stakeholders believed that activities toward concurrent planning could not be undertaken until there was a permanency hearing and until the court ordered it. I'm going to explain why that's not true. In other jurisdictions, it was really being used not as concurrent, which by definition is two simultaneous things, the pursuit of both of those plans at the same time, and rather it was being implemented as a primary goal and then a secondary goal that was a backup and was not really being acted on until that first goal either failed or was becoming very, very clear that it was not going to be successful. And then lastly, in some jurisdictions, concurrent planning was used basically in name only. We would see even as early as a dispositional order would identify the case plan and the permanency plan as reunification, and then would identify that every other permanency plan was the concurrent plan, which obviously does not fit the definition. So, as we saw across the various jurisdictions, there was inconsistent use. But what we also saw is that we did not have concerted efforts toward concurrent planning from the beginning of the case to the degree that is best practice and would reduce the time frame to permanency for children. So we look at where concurrent planning came from. I mentioned that it came early in my career with the Adoptions and Safe Families Act that was passed in 1997, and that was the first time that concurrent planning was introduced in child welfare law. And within that, it indicated that efforts to place a child in an adoptive home or with a guardian could be made concurrently at the same time as efforts to reunify the child with their parent. That was translated into Nevada law in 432B.393 subsection 2, and in that it permits concurrent planning. And another key difference is that it's permissive. It does not require it, but as we are talking about today, it is a best practice and should be something that should be considered with each case. Not every case is going to be appropriate for it though, and we'll talk about that. So in Nevada law, we can see that the agency that provides child welfare services may make reasonable efforts to place the child for adoption or with a legal guardian concurrent with at the same time as making reasonable efforts to reunify. And this is where the distinction about the agency's role, court orders, the court's role is first identified. The agency has this authority. There is no requirement for a court order or a permanency hearing in order to do this. So the goals of concurrent planning have been talked about and identified in a variety of different literature and materials and trainings. I felt that this was pretty comprehensive, and you can find it on the Child Welfare Information Gateway, a really good tool if you're not familiar with it. But the goals that are set out are to expedite permanency through either reunification, adoption, guardianship, minimize the child's separation from their caretakers when we're able to do that, keeping siblings together. This is a key one next, empowering parents by involving them in the planning. And we're going to talk a little bit more about this because this is one of the key components. And then communicating with the parents from the very beginning of the case and throughout the case, where they are, where things stand, but then again, trying to engage them in planning for their children. And that's a hard thing to do, but it's something that our social workers and caseworkers are being trained to do through various abilities to connect with parents, to be honest with parents, and to be sensitive to their feelings and their role within the case. Some other literature that has been identified and trainings that are out there are the Toolkit for Concurrent Planning, and this lists some essential components. One of the primary essential components is differential assessment and a prognostic case review. We would like to be able to believe and see through that every child could be reunified with their parents, but case statistics and reality shows that that's not true. And through various different models, there are some specific identified risk factors in the beginning of a case that will indicate that this case is not likely to be a successful reunification. And we have to be thinking about that realistically from the very beginning of the case and throughout the case so that we can determine whether or not that case is appropriate for greater efforts toward alternative permanency plans at the beginning. Full disclosure to all participants. We discussed that on the previous slide as well. And this is about just engaging all of the stakeholders and most importantly, the parents. Family search and engagement. One of the things that we see with regard to good concurrent planning is the key component of having a relative. We are able to have better conversations about alternative permanency plans when a child is placed with a relative within the family. It opens up a different dialogue and really makes the parents and the rest of the family feel more empowered because we're just talking about their family system and we're not breaking that up. But that is one of our biggest barriers, and we'll look at some of the barriers coming up. The family group conferencing goes along with that family engagement. Visitation between family and the child, again, sometimes easier said than done because we know that there are competing interests with visitation and with a child just being a child and being able to have that time. Setting clear timelines for permanency decisions. ASFA pretty much did that for us. Being transparent, and then we have some of the others. So concurrent planning is going to occur if the Child Welfare Agency determines that the safety risk posed is high, the prognosis for reunification is poor, and then we look at the appropriateness of various concurrent plans. As mentioned before, the key is early assessment and continued assessment throughout the case. So talking about those factors that give some prognosis about the likelihood of reunification or the barriers to reunification are included in the concurrent planning practice guide. I've pulled out just a few of them here. Clearly, one of the #1 things that we see is the history of substance abuse and either failure to seek treatment or failure to either engage in that treatment or be successful in that treatment. And we get into a lot of discussions about that because we know that people are going to relapse, but we really have to do some critical thinking about what that looks like. Was it a relapse? Is it ongoing substance use? So that's an area that we really have to do some critical thinking. Caregivers being unwilling to engage in safety services. And really importantly is the caregivers being unable to identify within themselves diminished protective capacities. We don't have to have them identify it in those complex words, but them being unable to see what the issues are, acknowledge what those issues are, it makes it an indication that it's going to be difficult for them to change. Of course, the prior abuse and neglect or repeated attempts to reunify the family. And again, ASFA identified that as one area where reasonable efforts toward reunification may not be appropriate. Mental health concerns are an unfortunate reality, but also sometimes very difficult to have a successful reunification unless the parent is able to acknowledge that, be aware of it, and engage in that treatment early on in the case. And then developmental disabilities and certain impairments. These are some of the saddest situations when the parent just does not have the ability to engage in what is needed to be able to safely parent a child. But again, all of these things have been identified through study as indicators of poor prognosis for reunification. So within Nevada, we have our practice model that lends itself to engagement of the family. And so early on, there should be that full disclosure to all of the participants, namely the parents, about the timelines and about the need for permanency. If we can educate parents about why their child needs to have that permanency, then they can be more informed and be more engaged in the discussion to be able to help plan for what would happen if they are not able to reunify. A difficult conversation to have, but one that's necessary. Extended family being identified is also very important. I mentioned that previously, but it is an ongoing struggle, particularly in areas that are highly transient. And Nevada is one of those highly transient states where a lot of times we don't have that extended family or much extended family within our state. And we know that cross-state case planning and placement is a difficult thing. And then really talking to the parents, as I've mentioned, about partnering with us. Having that conversation that as a parent with a child, you should be planning for what might happen to your child if you were unavailable or unable to continue parenting them. If you became ill, that's planning, and that's being an active participant and making the best choices for your child. So we talked about some of the barriers to concurrent planning. And these are ones that are going to be difficult over time to address, but if we are recognizing them and acknowledging them, then we can continue to work on removing as many of the barriers as we can. One of the highest barriers is high caseloads and staff turnover. When we talk about concurrent planning, and it was recognized back when ASFA identified it, and it continues to be recognized, is the fact that if you have two permanency goals that require different resources and efforts, we don't have two or double the amount of resources, namely the human capital, social workers and caseworkers, to be able to effectuate those services. So anytime we have a concurrent plan going, then we are asking that same worker to use efforts toward two different things. So needless to say, then we're going to have less efforts solely toward one or solely toward the other because they're making efforts toward both. That is a reality, and it's a reality that we have to acknowledge when we are making these decisions about court-ordered concurrent plans or the expectations that we have of our agencies. We would love to have unlimited resources to be able to do the very best for all of our families all of the time, but reality sets in. So we have to recognize that when workers have higher caseloads, they're going to have less capital of time and personal energy to be able to engage in, perfect efforts and full efforts toward two different plans. Lack of time is always an issue. And then one of the things that was identified and what we're trying to overcome here is a lack of understanding of concurrent planning from all of the stakeholders. Another one that is a key is the lack of placement resources. And lack of placement resources who are willing and able to be a legal risk is one way that we refer to them. So if we think about it, and we think about our foster families, oftentimes there's a distinction between a foster family who is interested in just fostering, and they're trained to support and assist reunification, versus a family who is seeking to adopt. When you have that family who's seeking to adopt, you are asking them to basically bring this child into their home, obviously, but also bring this child into their heart as their child because they're seeking to adopt the child. But then telling them, but don't get too excited about that because this child may end up reunifying with their family. That's a hard thing to do. We have some special families out there who are successful at that, but there are other families who are not. So that is one of the key barriers to really good concurrent planning throughout the case and all along the way. So what are the roles of the stakeholders in concurrent planning? Well, we have the agency attorneys like me. We look at cases along with our client and remind them about concurrent planning and have that conversation about, is this an appropriate case and what the timing is. The parent attorneys play a huge role in developing that relationship and that private relationship with their clients to be able to have those hard conversations in a setting that the client doesn't feel any shame and can really express themselves without everyone else hearing about it. So they play a key role in that encouragement and to have the parent engage. And then the child attorneys and CASAs play a role in having that relationship with the child, helping identify relatives, advocating for concurrent planning when it's appropriate. And they play that role in explaining to their client, the child, what a concurrent plan is. And having experienced that, that is sometimes a challenging role depending on the age of the child. And then the judges. So judges play a role even from the beginning, even though it doesn't involve court orders. They play a role in that concurrent planning versus a court-ordered concurrent permanency plan by asking the stakeholders, have you considered concurrent planning? By engaging the parents to say, it's really important for you to be part of this process and you are a valuable stakeholder in this team. Encouraging parents to provide information about relatives and explaining why. And then as the case goes on, continuing to ask the agency about concurrent planning and when appropriate, we'll talk about when this is, entering court orders for either concurrent planning activities or court orders that identify specifically a concurrent permanency plan. So as I've been talking about through this training, you can see that concurrent planning is a process, and it's one that really doesn't stop throughout the life of the case. It starts with engaging the parents, identifying relatives, then engaging those relatives, assessing reunification critically and honestly, and then considering the appropriateness of what the other plans are. So let's talk about what is appropriate for concurrent planning and what's appropriate for concurrent permanency plans, depending on the different circumstances of a case. And I'll give some examples of that. Generally speaking, reunification is the identified permanency plan from the beginning of a case, unless certain factors have been identified that would make reunification not appropriate from the beginning. But generally speaking, we're going to say reunification is the permanency plan. Concurrent planning would then indicate at that time of assessing the case from the very beginning is looking at who are the relatives. That is pretty much the key #1 component of early concurrent planning. Because if we can identify those relatives, then we can make a determination whether or not a guardianship might be appropriate down the line if reunification is not successful, or whether or not adoption is an appropriate alternative down the line. And the difference between guardianship and adoption are largely going to depend on whether or not the child is able to be placed with a relative or not placed with a relative. If they can't be placed with a relative, then we're generally not going to be speaking about guardianship. So that identifies adoption. One of the areas where concurrent planning around adoption would occur then is looking at what the appropriate placements are. Do we have a legal risk resource family that's available from the beginning of the case? Do we need to initiate interstate compacts for the placement of children, either for a relative or looking at a potential adoptive placement? If it's a potential adoptive placement that's not a relative, that's going to be far down the line. And importantly, if we're looking at a concurrent plan with regard to APLA, another planned permanent living arrangement, we have to make a recognition that APLA by federal law and by state law is not available unless the child is 16. So we can easily say now that it is never appropriate to have a court-ordered concurrent plan of reunification and APLA if the child's not 16. Because again, these are plans that are required to be worked on. If the court identifies it as a plan through court order, reasonable efforts are required to be made toward both of those plans equally. And so that's going to be one of the factors that we look at in terms of, is an official concurrent plan versus concurrent planning appropriate in this case. But concurrent planning for APLA could be appropriate if the child is nearing the age of 16 and you're providing then those independent living services. You're providing the efforts to try and connect that child with an adult who would be consistent throughout that child's transition into adulthood. You can be doing those activities while the child is aging to 16. So let's talk about what happens from concurrent planning that we've talked about now to identifying specifically concurrent permanency plans. And that occurs in two ways. One way is if the agency identifies it in their case plan as a concurrent permanency plan. Once the agency does that, pursuant to the federal reviews, the agency will be reviewed on their efforts toward reasonable efforts toward finalizing those permanency plans, both of them. Additionally, if it's identified as a concurrent permanency plan in a court order following a permanency hearing, then the agency is going to be reviewed on their reasonable efforts to finalize both plans at the same time. So we have to consider whether or not it's appropriate to finalize both plans and make those efforts toward both plans at the same time within this particular case. And some examples, and we're going to talk about more examples of this during the panel discussion later, so I'm not going to go into a lot of detail about every potential scenario, but a couple of scenarios that are appropriate. One is whether or not it should be a reunification or concurrent plan of reunification and adoption. This is probably the most common concurrent plan that we see. And when we're looking at that, once we say that adoption is one of the permanency plans, that triggers timelines for the agency and their counsel to initiate termination of parental rights proceedings. Under our statute, in 432B.590, it says that if the court identifies termination of parental rights and adoption as a permanency plan, then the court shall use its best efforts to ensure that that is completed within 6 months. So those timelines start. Under the federal law, there's also requirements to initiate the termination of parental rights proceedings unless the court has made compelling reasons, findings of compelling reasons to not have termination of parental rights be filed. And so those timelines get triggered. Well, if we do not have a potential relative placement, if we have an older child who is of the age to be required to consent to an adoption, that age in Nevada being 14, if we have a child who is in the position at that point in time of saying, I won't agree, I'm not going to sign a consent to an adoption, that doesn't mean that concurrent planning for adoption doesn't continue. By continuing to work with that child, by continuing to search for an appropriate family. There's been more than one case where that family comes along and that child changes their mind. So that's concurrent planning. But to identify as a court-ordered or in the actual case plan by the agency, the concurrent plan of adoption, if we're not able to take steps toward that, that's when it's not an appropriate formalized concurrent permanency plan. So that's one of the examples that we see most often with regard to the reunification and concurrent plan of adoption. Another one is to keep in mind the issue of whether or not reunification is an appropriate continued concurrent plan. We might be at the point of not having an adoptive family. but the parents are not making progress toward reunification. And so it's identified that adoption is the appropriate plan. We see often, for a variety of reasons, the court saying, well, I'm not going to adopt the plan of adoption only. We want the parents to have additional time. The parents are engaged in some of their services, but not all of their services. And so we're going to have the concurrent plan of reunification. We need the stakeholders to understand the effect of that. If we have the parents' rights still intact and we are working those efforts toward reunification, our pool of resource families who are willing to be a legal risk for an adoption narrows. And that's one of the things that we talked about with regard to barriers. So sometimes it is going to be more difficult than to find a family who is willing to have that emotional and family engagement fully around planning for adoption, but knowing that that might not occur. And so in those situations, it may not be appropriate to continue with the concurrent plan of reunification. And then finally, when we're talking about when it is and is not appropriate for concurrent planning, we need to always remember that the focus is with regard to what is in the best interest of the child. And sometimes we have to listen to how the child feels about having concurrent plans. Sometimes that can be confusing and cause them some anxiousness, anxiety about having two different plans going and them not feeling that they have a permanent goal in mind and being able to focus on that goal. So we need to listen to the children through their attorneys and CASA representatives about how the impact is on them. And in addition to considering the child's perspective, we also have to consider all of the factors related to what is in the best interest of the child here and now. So that is the end of the training with regard to concurrent planning. A lot of it, I think, in wrapping up, we can talk about being something that's necessary from the beginning of the case, considering it all the way through the case. All of the stakeholders have a role with regard to concurrent planning, and at some point having formalized, identified concurrent permanency plans in the case plan and through court order can be appropriate, but we have to be thinking critically about whether or not it's appropriate in this particular case, whichever one we have in front of us. So that's all I have for now, and it was really a pleasure to be able to provide information to you and to continue to work with the stakeholders throughout our great state of Nevada.